The AIA's A102-2017 owner-contractor agreement is absolutely one of my favorite contract documents. I use it all the time, and I would encourage both contractors and owners alike to give a lot of consideration to using the A102 as their contract document of choice when they're embarking on a new project. Of course, this is one of the AIA contracts that envisions a project delivery method where the owner is going to separately contract with the architect over here with one contract, and the owner is going to separately contract with the contractor over here in another. This is the one that we're talking about today, the A102-2017. And the major differentiator between the A102 and its cousin, the A101, which is another document that I really love and I use a lot, is that the A102 envisions a cost reimbursement method of compensating the general contractor. That's the major differentiator from the A102-2017, the cost plus agreement, and the A101-2017, which is a contract which envisions that there's a fixed contract sum. And if you read the name of the A102, the full name, you really get a sense for what the differentiator is and why the reason somebody would select the A102 over other contract documents is that they wish to compensate the contractor using this cost reimbursement method as opposed to using a fixed contract sum method. So let's break apart the name, the full name of the A102-2017. So it is AIA document A102-2017, the standard form of agreement between owner and contractor, which is all quite simple. And how we get to the juicy part, where the basis of payment to the contractor is the cost of the work, and cost of the work is capital C, capital W, because that is a defined term which is code for the kinds of costs that the owner is going to reimburse the contractor for. And there are provisions in the A102 which explain what kinds of costs might be incurred by the contractor that would not be reimbursed by the owner to the contractor. So the basis of payment is the cost of the work plus a fee. That fee is typically percent based, a percent of the cost of the work, with a guaranteed maximum price, which is sometimes known as a GMP or is sometimes called a GMax. There's really no difference between GMP and GMax. And so again, the A102 is the form of owner-contractor agreement that would be used in cases where the owner wishes to pay the contractor not a fixed contract sum, which is what you have under the A101-2017. But again, they're going to pay the contractor the cost of the work that they incur that falls into the category of cost of work, capital C, capital W, as the term is defined in the document, plus a percent-based fee with a guaranteed maximum price. And a guaranteed maximum price, of course, is a ceiling. So what we're really saying here is that the owner is going to pay the contractor certain categories of costs, actual costs that the contractor can demonstrate that they incurred as they're, properly performing the work. And those costs are going to add up, and there is a ceiling. That ceiling is the GMP. And so, when I was a young construction lawyer, I remember going to one of the partners who I worked for and expressing some consternation over, boy, guaranteed maximum price and fixed contract sum, those words really sound very similar. What's the difference? And, what my former partner helped me understand was, if you're using an A101-2017 or any kind of a contract, whether it's an AIA contract or a consensus docs agreement or an EJCDC contract document or any other standard form of agreement written by an industry group, or whether you're using a contract form of your own creation, when you are paying the contractor a fixed contract sum, it's really quite simple. The owner will be billed a percent complete. And So there's not a lot of questions or confusions or complexities around how you administer a fixed contract, some contract between the owner and the contractor. But when we're going to do this cost reimbursement arrangement, where there's only certain kinds of costs that are going to count, that are cost of work that add up, and you're going to have this guaranteed maximum price, what we have here is a situation where the contractor might come in under the guaranteed maximum price, creating what's known as savings, okay? And one of the main reasons why an owner might wish to pursue a cost reimbursement contract is if they believe there's a chance that they might have their general contractor complete the project well below the guaranteed maximum price, creating savings. And so there's, that upshot for the owner potentially of paying less money. There's also a scenario where the general contractor would complete the project by exceeding the guaranteed maximum price. And of course, there are change orders and scope creep and all sorts of ways that the guaranteed maximum price can move throughout the course of the project, just the same way that a fixed contract sum can move by change order and through other means. So it's not to say that the guaranteed maximum price that's set at the outset of the contract execution is the final, but there are scenarios where, in addition to the owner having to pay under the GMP and realize savings, there are situations where the contractor will incur costs in excess of the GMP, and those costs, all things being equal, are borne by the contractor. So even though a fixed contract sum and a guaranteed maximum price sound like very similar concepts, they're really quite different. And one of the reasons why I've said in the past that all things being equal, I would prefer an A101, a fixed contract sum, over an A102, the cost reimbursement method, is because the A101 is just simpler. The A101 has got 10 pages less of standard text because you don't have to worry about detailed recitations of what sorts of costs fall within the category of cost of work, capital C, capital W, and will be reimbursed, and what kinds of costs are not. And that's just the tip of the iceberg. Any kind of cost reimbursement contract, any kind of guaranteed maximum price contract is always going to be more complicated and difficult to administer. So all things being equal, even though I love the A102-2017, I use it all the time, constantly. There's almost never a time when I'm not negotiating an A102. All things being equal, I'll take the A101-2017 because I prefer the fixed contract sum approach because it's simpler and it's less likely to lead my clients into the sorts of disputes that are the whole reason that my law firm exists. I'm here to help people complete projects without disputes. So if we take the assumption that the A102 is a great document and it has a lot of advantages and I use it all the time, even though it's a little bit complicated, it's worth focusing on what would motivate an owner to go ahead and use the A102 or any kind of cost plus GMP, GMAX agreement, any kind of cost reimbursement. I touched on the first, right? It's the possibility of these shared savings, right? So if the GMP is $1 million and the contractor is able to complete the project for $900,000, you have $100,000 of savings. And it is something that a lot of real estate developers and commercial property owners are interested in pursuing. They're interested in pursuing those savings. They figure, why should I just agree to pay the contractor $1 million when maybe it'll only be $900,000? And so it's this possibility of achieving savings under the GMP, which would motivate an owner to use this particular kind of contract form. And so all that I would say is that while it is often the case that owners can achieve savings under the GMP, I don't want to burst a lot of real estate developers and property owners' bubble, but the possibility of savings under the GMP is often illusory. And it's often something that is not likely to really be realized. And so it sort of begs the question, if you can spot that at the outset of the contract, why would you pursue these illusory savings and take all the pains and the problems of a more complicated contract document that's got more words and is more difficult to administer? And so the reason why I think that the savings tend to be illusory in many instances, not every instance. I mean, I'm always watching a lot of my real estate developer clients realize savings under the GMP, but they know what they're doing and they have smart contracts and they know from the beginning they've got a good chance of realizing those savings. The reason why they're illusory is it's quite simple. It's really the blinding flash of the obvious. You know, a contractor is not going to be able to give you a guaranteed maximum price unless the architectural and engineering drawings are precise enough, I'm using air quotes, to allow the contractor to give some kind of a GMP, right? A contractor is not going to set a guaranteed maximum price or a fixed contract sum if they don't have a pretty good understanding about what it is that they're going to be building. And so if you look at, if you take that assumption and you assume that you've got an honest contractor whose eyeballs are connected to their brain and they're looking at a reasonably detailed set of documents, if they're going to come up with a guaranteed maximum price value for you to put into your A102-2017 before it's signed, one of two things must be true. Either the contractor is an honest broker that has a lot of fidelity to creating a GMP that is on the money with what they really think they're going to wind up incurring in terms of costs. And if they wind up hitting the GMP right on the nose, there's no savings. So if you have an honest contractor and there's not a lot of ambiguities, there's not a lot of allowances, if the drawings are reasonably complete, either they're going to nail the GMP and it's going to be pretty close to what a fixed contract sum would be, and it's going to be a pretty good approximation of what it is that they really think they're going to spend, and then the savings potential is illusory, or the contractor is going to artificially inflate the GMP, and they might be thinking, well, it's probably going to be $1 million project, but let's put the GMP at 1.1 million so that it's easy for us to go to the owner and say, look at all these savings that we created. And so if you are a real estate developer or a commercial property owner and you are debating between using a fixed contract sum contract document like the A101-2017 or a cost reimbursement contract document with a guaranteed maximum price like the A102-2017, you're going to want to take a really good look at the question of, is the potential for savings under the GMP illusory, or is this something that could really happen? And there's a whole variety of good reasons why an honest contractor and a smart owner, depending on the facts and circumstances of the project, depending upon its nature, depending upon how complete the drawings are, and a lot of other things, there really is the potential for savings under the GMP in a lot of instances. But there's also a lot of instances where just like out of the gate, one of my real estate developer clients will come to me and say, we want to use the A102-2017 because we want to seek savings. And I got to say, guys, gals, like I don't see it. So this is something that well-advised developers and property owners are really going to think about before they're going to opt for the more complicated method of reimbursing the contractor. I should also point out that there is a lot of upside for contractors in a cost reimbursement model as well, because if they're actually able to achieve savings under the GMP, it's usually the case that those savings are shared by the owner with the contractor to try to incentivize the contractor to not spend every dollar of the GMP. Obviously, if you take a step back and you think about it, if the contractor's fee is percent-based, in other words, they get 4% or 5% or 7% of whatever cost of work they incur, their instinct is going to be to spend all the dollars all the way up to the guaranteed maximum price so that they can get the highest percent-based fee. So how does a smart owner overcome this moral hazard? Like, how do they align their financial incentives with the contractor? Well, they share some of those savings with the contractor under the GMP. It's one of the reasons why sometimes contractors would artificially inflate the GMP, because they really want to get those shared savings with the owner because that'll supercharge their profits. And this isn't the sort of thing that would necessarily occur to everyone that doesn't deal in this area, but it's the blinding flash of the obvious that, say for the sake of round numbers, that the contractor is getting a 10% fee on the cost of the work. Every dollar they spend, they get a dime. But if the owner were willing to share savings 50-50 with the contractor, instead of getting a dime for spending a dollar, they get 2/4 for saving a dollar, which is a good deal for the owner too, because the owner wants to align their financial incentives with the contractor. They want the contractor to be as motivated as possible to not bump up against the GMP because the owner wants to spend as little money as possible. So there's really good reasons for owners and contractors to want to pursue a cost reimbursement method of project delivery, of reimbursement. However, it is a more complicated method of compensating a contractor. It leads to longer contracts with more words, and there's more complexities in administering the contract on a month-to-month basis when the pay applications come in, and then when you get to the end of the project, because there tend to be audits of actual costs and a lot of other things which can breed disputes. So unless there's a good reason, unless there's a legitimate, earnest, well-founded belief that there could be shared savings under the GMP, my instinct is to try to steer my owner and developer clients into an A101-2017, which uses that fixed contract sum where the contractor is paid on a percent base, because I really want to keep my clients out of disputes. That's sort of the reason my law firm exists. One of the other good reasons why an owner may wish to opt for a cost reimbursement model of reimbursing the contractor over a fixed contract sum is if they need to get a shovel in the ground fast for whatever reason. Maybe their funding is contingent on breaking ground in a certain time frame. Maybe they just really need to be able to take their product to market. Maybe they need to achieve substantial completion within a certain amount of time in order to begin to have the project cash flow so they can service their loans. Whatever it is, if an owner needs to get a shovel in the ground before the architectural and engineering drawings are advanced enough for a contractor to agree to a fixed contract sum, that's another reason why sometimes an owner and a contractor, even if maybe they don't see the potential for shared savings, might wish to pursue a cost reimbursement method of compensating a contractor under the A102 rather than a fixed contract sum method of reimbursement under the A101. All that I would say about that is that obviously if the contractor is going to give the owner any kind of a GMP, the drawings that are prepared by the architect and engineer have to have some detail. They have to have enough information to give the contractor the idea that it's going to be a $10 million project and not a $20 million project. And so if they're able to understand enough about what the owner wants, even if ground is going to have to be broken before the drawings are sufficiently complete to give a total price, then, there are ways that an owner can get into a fixed contract sum agreement that just has allowances or some other placeholder. So I wouldn't necessarily say that an owner or developer that feels like they need to break ground very quickly absolutely has to go with a cost reimbursement method of project delivery. You could really do either one. So all things being equal, I'll take a fixed contract sum agreement every day over a GMP agreement unless there's a really good reason for my owner or developer clients to opt into the more dispute-prone, more complicated, longer, more complex to administer cost reimbursement method of contracting. And that's the principal downside, right? I mean, if you were to hold the A101 and the A102 up side by side, you would see that they are similar in many ways, but the A102 is about 10 pages longer because it has to deal with some of this complexity, and that complexity breeds disputes. Or at least it can breed disputes if you have people who are chasing illusory savings or doing things, that are maybe not the best strategy when they are picking their method of project delivery and their contracting strategy. As is the case with any AIA contract where the owner separately hires the architect with one contract over here and a second contract with the constructor over here. Whenever you have that arrangement, 90% of the time, any owner-contractor agreement is going to be paired with another very important AIA contract document. That's the A201-2017 general conditions. The A201 is a document that sort of sits between the owner's contract with the GC over here and the owner's contract with the architect over here. It kind of sits inside that triangle, and it explains not the business deal, right? The owner's agreement with the contractor's got their business deal. The owner's agreement with the architect's got their business deal. The A201 general conditions kind of sits in the middle of that tripartite relationship and explains the way that the owner, the contractor, and the architect are going to play nicely in the sandbox together. For example, most contractors might not be thrilled about the idea that it's going to be the architect that is going to certify a payment application. And, that certification is going to trigger the owner's obligation to pay the contractor. I think a lot of contractors would prefer to not have the architect in the middle of that arrangement. But the A201 general conditions is the document that sort of says that that's the reality of the situation. So regardless of whether you use an A101-2017 or an A102-2017 or any other AIA contract where you got the owner separately hiring the architect and separately hiring the contractor, you absolutely need to look at the A201 general conditions. It's got 38 lengthy pages of essential terms that an owner, a contractor, and an architect are going to be bound to, that they cannot do without. Just to give you an idea, the A201 says the word contractor in it more than 500 times. It says the word owner in it more than 400 times. And it says some variation of the word architect or architecture almost 300 times. So any owner or architect or contractor that is going to be in this relationship where the owner separately hires the contractor, separately hires the architect, if they are not looking at the A201 general conditions and realizing that it is incorporated by reference into their contracts, it doesn't have to be signed. So it's automatically incorporated by reference into the contracts, whether people know it or not. They're really shortchanging themselves. That's a very important point that people need to understand if they're going to have their eyes open on what their contractual obligations are. Just to give you a general idea, Article 8 of the A201 talks about time, delay, extensions of time, things of that nature. Article 9 addresses payment process, what's the role of the architect. There's really important terms in Article 10, which addresses safety. And then there's a very substantial part of the A201, Article 11, that deals with insurance. Owners, architects, contractors absolutely need to be aware of the entirety of the A201-2017, 38 pages long. It's got a dozen articles. They're essential. So regardless of whether you use an A101-2017 or an A102-2017, make sure you look at the A201 general conditions. I've got a lot of videos on this, including a 90-minute presentation on the ins and the outs of the A201 general conditions on my website. In addition to the general conditions document, the A102-2017 uses an insurance exhibit. That is a document that explains the insurance that the owner and the contractor are each respectively going to bring to the table. That exhibit plays off insurance language inside the body of the A102. It also plays off language inside Article 11 and other aspects of the A201. So these really all are intended to work closely together. Any owner or contractor is going to absolutely want their insurance broker or risk manager to have eyes on not just the insurance exhibit, but the insurance-related language in the A201 and the insurance-related language in the A102 before you execute any of those documents. And like, any contract document that, is sold by an industry group, comes off the shelf, the A102-2017 that you get from the AIA, it's just a starting point. It's just the beginning point for negotiations. I never, ever, regardless of whether I'm representing a real estate developer or a commercial property owner in the negotiation, regardless I'm representing a contractor, it's never the case that we're just going to take the AIA agreement off the shelf, fill in the blanks, and sign it. They absolutely have to be customized. There are state law specific edits that need to go in the document that make sure that it complies with the prescriptions of state law and the prohibitions of state law. There's a bunch of stuff in almost every state that talks about payment and the payment process, and prompt payment, and is there a prevailing wage requirement? What does the Mechanics Lien Act require? Does it require sworn statements and lien waivers? And what's the obligation of the project owner if they get these documents and they have certain content? So you're going to want to tailor any contract, including the A102 2017, to talk about these issues and to talk about retainage. Most states constrain how much retainage can be retained and by the owner and for how long. Most states are going to have limitations on how far an indemnity clause can go and still be enforceable. And then, just like every other contract that I ever negotiate, the first thing that me and the other lawyers in my firm are going to do is we're going to make project and client specific edits based on what we call an issue spotting exercise. We will ask our clients, send us the request for proposal, send us the proposal, send us your clarifications and assumptions, send us scope documents, send us documents that you put into the local permitting agency that describes the project. Let me understand, is this a rehabilitation with hidden conditions? Are we going to be digging near a boundary line? Is there aspects of the project that's public funding that might trigger certain requirements? So I have to do my issue spotting exercise in order to make those custom edits in there. And just to give you an idea, I talked about how sometimes you're going to want to get a shovel in the ground quick, and it's kind of hard to use the A201, which calls for a GMP to be inserted when it's signed. If an owner wants to do the cost reimbursement method, wants to get a shovel in the ground, maybe the drawings are not at all complete and insufficient for the contractor to provide any kind of a GMP, but they come to me and they say, Jeremy, we want to pursue those shared savings. We really want to do this. I can make all kinds of edits. I can and frequently do take the A201 2017 and add a few more pages of text which says there won't be a GMP now. The GMP is going to come later. And, we're going to release the contractor to do some civil work and site work and dig the foundations because that package is ready to go. But at some point in the future, here's the process for the contractor getting us a GMP that we would include in the contract, the A102-2017, as an amendment down the road, because, we anticipate that in 9 months, we're going to have complete architectural and engineering drawings, and we'll be able to do that. So any of these documents are going to require customization for a variety of reasons. A lot of it has to do with what my clients want. Some of it has to do with the constraints of state law. Some of it has to do with the constraints of the project and its participants. And so, to conclude, I absolutely love the A102 2017, the standard form of agreement between owner and contractor, where the basis of payment is the cost of the work plus a fee with a guaranteed maximum price, a GMP or a GMAX. I think it's a great document. I am negotiating them all the time. And just because I tend to prefer fixed contract sum agreement, all things being equal, that's no reason to shy away from using the A102 2017 if it is a situation where it is advantageous for the project owner to select that method of compensating the contractor.